Hi, everybody. My name is Mark Donig. I am of counsel at Grossman, Young and Hammond, one of the leading immigration law firms in the country, and really pleased to be able to present this presentation on primer on high skilled immigration here with my colleague, managing partner at Grossman Young, Becki Young, along with Christine Stevens-Bez. So this webinar, the goal of this webinar is really to provide an overview of the U.S. immigration system, focusing on the fundamentals of employment-based immigration and an overview of visa options available for high-skilled foreign nationals. As we know, right now is a very complicated time, in the world generally, and along with that, in the immigration space specifically. And so, we're really pleased to be able to present, this expert panel to help kind of navigate some questions that I know each of us personally and all of us collectively have either been asked or may ourselves have. So we're going to discuss the key categories, the key visa categories for entrepreneurs, executives, and other professionals. And so, again, my name is Mark Donig. I'm of counsel at the firm. I've been at Grossman Young now for just a little over a few months, but I've had the privilege of working with Grossman Young for close to a decade, from the time when I was at Big Law, at various firms in Silicon Valley, New York, and DC, working on a variety of these high-skilled visa efforts before formally joining the team. And so I've been privileged over that time to work with now my boss, Becki Young, who's a founding partner and a seasoned business immigration attorney with 3 decades of experience in the field. So Becki regularly provides immigration law advice to clients in a broad range of industries, investment securities, information technology, nonprofit, manufacturing, healthcare, and on and on. And she has extensive experience in a variety of these, in practically all of these different areas of immigration law and high-skilled visas that we are going to speak to today. So, and then Christine Stevens-Bez is a senior business development manager at Cultural Visas, a designate sponsor by the U.S. Department of State, working for the J-1 visa. And so she's going to be able to add some insight a little bit later on in this webinar on the J-1 visa. She's been working in this space for over 10 years and is an expert in the J-1 research scholar and specialist visas. So let's just jump right in. So Becki, I know that immigration is considered one of the most complicated areas of U.S. law, up there, with tax law and other things that people just sort of, their eyes often glaze over when they start thinking about immigration law, unless they're a specialist. So in 5 minutes or less, can you describe the overall structure of the U.S. immigration system for those of us who may not be as initiated and expert in the way the system works?
No problem, Mark. I would be happy to do so. The immigration system, employment-based immigration, has basically 2 components, which are non-immigrant visas and immigrant visas. We're going to be talking about both of those today, and we're going to do our best to keep the presentation part of this hour to 30 minutes, because I suspect that a lot of you are here because you may have questions about how all this relates to what's going on in the world. And so we do want to provide ample opportunity to ask questions at the end. We're also really happy that Christine is here. We had initially created this webinar to talk about some of the main categories of visas that are filed with the Immigration Service, which are H-1B, L-1, O-1, and also E, which actually is not always filed with the Immigration Service. But anyway, those are sort of the 4 categories that people most commonly think of when we're talking about high-skilled immigration. And Christine offered to join us to talk about J-1 specialists and research scholars, which are maybe a lesser known but very important category of high-skilled visas. So usually people start with a non-immigrant visa. It's quicker to get, it's easier to find someone to sponsor you, it's less expensive. And so we call these non-immigrant visas sort of an alphabet soup because they all have a letter assigned to them, A, B, C, D, E. You might have noticed I was talking about H's, L's, O's, and E's, and J's. And going through the alphabet, we're only going to talk about those 5 non-immigrant categories today. There are non-immigrant visas going all the way up to, I think, the letter V. So there are a lot to remember. But these are the ones that we want to focus on. And we picked this topic because obviously in the news, there's a lot of conversations about all sorts of immigration, a lot of focus on undocumented immigration. And there have been some conversations about high skilled immigration. And I think that the view of the administration on these visas is evolving and maybe hopefully in a positive direction. We shall see. But I think it's really important, especially in the current climate, for us to understand when we read about high skilled visas in the newspaper, what does that term actually mean? So that's what we're going to tell you about today. And then with regard to green cards, so as I said, all of these sort of temporary visas tend to be the first step for someone who wants to come to the US in a high skilled category. But after they're here, many people will be sponsored or in some cases sponsor themselves for a green card. And so there are corresponding green cards. One is called PERM or labor certification, and that's sort of the most basic type of employment-based green card. There are also EB1A, which are extraordinary ability green cards. They are similar to the O1. There are national interest waiver green cards, which relate to someone whose work is in the national interest. And those are two special categories that allow for self-sponsorship. There are EB1C or multinational manager green cards. And then finally, there are EB5 or investor green cards. So we'll talk about all of those today. So that's just a basic introduction to the structure of the employment-based immigration system. Mark, you're muted.
Oh, I'm sorry. I had a little background noise, so I muted myself for a second there. So let's do a dive into a little bit of the specifics of each of these categories. So I understand that the H-1B professional worker visa is the most common type of U.S. worker visa, and that the PERM or labor certification is the most common type of employment-based green card. So can you tell us a little bit more about each of those options to kind of kick off our discussion on more of the specifics?
Absolutely. And I put these two together because, as you said, the H-1B is the most common temporary visa. The PERM is the most common employment-based green card. They don't necessarily go together. You can have an H-1B and you can get an EB5 investor green card or vice versa. But typically, this is a very common fact pattern we see that somebody will come on an H-1B visa and then be sponsored for a PERM. So an H-1B is sort of the basic bread and butter professional worker visa. And this visa is for skilled workers. So it requires that the individual in question has a bachelor's degree in a specific subject and that the job being offered in the US requires that bachelor's degree. So some good examples might be a lawyer who has to have a law degree, an accountant who has to have an accounting degree, a medical doctor. We see a lot of these in information technology. So computer systems analysts and various information technology related professions are also very common among H-1Bs. Any job that requires a degree, but it's important to understand the degree has to match the job. So if you have a degree in botany and you want to work as a computer programmer, that's not going to work. There are some ways to show equivalence to a degree through a combination of education and experience. So if you have, for example, a foreign associate's degree and 6 years of experience, you might be able to show that that equates to a degree. There also are many people with US degrees, but also many people with foreign degrees who undergo this process. And those individuals with foreign degrees need to get their degrees evaluated for US equivalency. So the individual has a degree, the job requires that specific degree. The employer has to show that they're paying the proper wage. And this is very important because the current administration has really expressed a concern for protecting the US workforce. And so the H-1B program is set up to protect the US workforce through these provisions. The first step of the H-1B process is the filing of an LCA, or labor condition attestation. And that's a filing that the employer makes to show that they're paying the higher of either the prevailing wage in the geographic area or the actual wage at the employer's work site. So the prevailing wage is determined by the Department of Labor. There's a publicly available database where you can see what is the wage, for example, for an entry-level attorney in Washington, D.C. For any job anywhere in the country, the Department of Labor keeps statistics about what is the prevailing wage. And so in order to not undercut the local labor market, the employer has to pay higher than that wage. But the employer also has to pay higher than its actual wage. So for example, let's say the lawyer wage for an entry-level lawyer is $80,000, but it's big law, so they're going to pay $180,000. The employer also has to comply with the actual wage range in their company in that location for those workers. So those are the protections that are built into the H-1B process for wages and protecting U.S. workers. And during the prior Trump administration, those wages were definitely the subject of some controversy. And there was a move to require employers to only use higher level wages. So there are 4 levels of these prevailing wages, going from an entry-level worker to a highly experienced level worker. So we don't know whether we'll see that again, but it is possible that there could be some policy proposals about requiring higher level wages for H-1B workers. But that's how the Department of Labor portion of the H-1B works. After the employer gets this Department of Labor filing approved, and by the way, this does require a posting at the employer's premises, so there is a notice that's provided to U.S. workers of the sponsorship of a foreign worker under the H-1B process. So after that's filed, then there's a filing made with USCIS, the United States Citizenship and Immigration Services. And that filing, in addition to the DOL component, requires the employer to document that the person has the degree in question. If it's a foreign degree, that it's been evaluated as equivalent to a US degree, that the job offered requires the degree. There are a few other issues that we sometimes see in the H-1B relating to viability of the company. So if it's a new startup company, we might see issues about that. I want to mention one other thing about the H-1B, which is that you might have heard about the cap. So H-1Bs are subject to an annual quota, and the H-1B cap is happening right now. When I say right now, it's starting on March 7th. And there's a 2-week period during which employers can register new H-1B workers. So that's a very busy time of year for all immigration law firms and individuals who want to enter the H-1B. So I think that's all I'm going to say about the H-1B for now. I want to talk very briefly about the PERM, but I know we're trying to keep this to 5 minutes. So I'm going to very, very briefly address the PERM, and then we can, if there are questions about it later, we can talk about that. So the PERM, which is the basic green card process, also has labor protections to show that the sponsored worker is not taking a job from U.S. workers. And this requires conducting a recruitment through the Department of Labor to show that no U.S. workers who are able, willing, qualified, and available have showed up to apply for the job. So in many of the cases where we do PERMs, there really are employers who might be in rural areas or otherwise have jobs where they really can't find U.S. workers for those jobs. And so this is the type of job that would be successful in a PERM application. So that filing is made with the Department of Labor. After the first step, the second step is a filing with the Immigration Service to show that the employer has the ability to pay the offered wage and is really offering that job. And then the final step is the green card application for the individual worker. So I'm going to stop there. That's a very basic overview of PERM, which is actually one of the most complicated things we do as immigration lawyers. So if anyone has questions, feel free to ask them later.
Yes, thanks. And just making sure that please, there is a Q&A. There is going to be a Q&A component, so please have your questions ready. Next we're going to go. So basically, the overview here is we're talking about different categories of these high-skilled visas. We're going to cover a number of different categories, but let's turn next to the E and the EB-5. The E visa and the EB-5 green card, which are for treaty traders and investors. Can you give us a quick overview on what we need to know about those visas?
Absolutely. So treaty trader and investor non-immigrant visas are based on reciprocal treaties between the United States and the country of the foreign national's origin. So the first thing that we do if someone wants to apply for a treaty trader or treaty investor visa is to see whether the United States has an investment treaty with that individual's home country. And then if so, I'll talk about the E2 treaty investor because that's much more common than the E1 treaty trader. So the individual has to make a substantial investment in the United States, in a business in the United States. Substantial is not defined, but suffice it to say that it does have to be, a fairly, it can't be a business operating out of your basement where you're the only person there. You have to show that you're going to be operating a viable business, that you're going to be employing US workers, and that you have a real solid plan to grow and expand that business. And so this is another category that was definitely scrutinized during the first Trump administration. There were protections put in for US workers. I think this is a category that really the administration should like because these businesses do tend to provide employment for US workers and really contribute to the economy. So treaty trader is a pretty popular one. They're typically done at the embassy rather than at the immigration service. You can file them internally, but just because of the way that they evolve through investment treaties, they tend to be filed at consulates. The EB-5 is an interesting category, and we have one of the top EB-5 lawyers at our firm. His name is David Morris, and he provides excellent guidance on this topic. So the EB-5 allows for foreign nationals to invest either in a designated regional center or their own business. We tend to see a lot more cases where the investment is in a regional center, just because that's a much more straightforward path, much less risky. And it also allows for a passive investment. So the E2 that we just talked about does not allow for passive investment, but the EB-5 green card does. The EB-5 was in the news recently. The president announced that he wanted to offer something called a gold card, which would be not an investment in a business, but just a donation to the US Treasury. So this is different from that. And this visas category, green card category, is definitely being discussed at this time. So I think we'll definitely see EB-5s in the news in the days to come.
Yeah, thanks, Becki. It'll be interesting to see and wonder also if you have kind of any insight. Does the firm have any insight as to more details about this new visa category that the president has been proposing, this gold visa, whether it's actually likely to happen? Can it happen just by way of executive order? Any additional insight on that?
So it's our opinion that it should not be able to happen via executive order. Typically, that is something that would require legislation. I guess, though, that remains to be seen.
Okay, so stay tuned on that, and if more action happens, maybe another cause for another webinar for this group. Let's next move to the L1 and EB1C. The L1 visa for multinational managers and their corresponding green cards. Can you tell us more about those?
Absolutely. So this is a preferred category, and the way that you can tell is that the green card is EB1C. So EB1 means employment-based first preference. So within employment-based green cards, there are preferences 1 through 5. Although interestingly, the EB5, which is the last one, is also, I would say, a preferred category. It just sort of got added on there at the end, though, which is why it's designated by a 5. But anyway, typically EB1 are the immigrants who maybe contribute the most, at least in the opinion of policymakers, individuals with extraordinary ability, and executives and managers from multinational companies, as well as outstanding researchers. So those are a preferred category of immigrants. So that's the immigrant version. The L1 is the non-immigrant version of that visa. And so basically, if you are a foreign company with a parent, branch, subsidiary, or affiliate in the US, you can sponsor individuals who are working at your company as managers or executives. You can also sponsor specialized knowledge workers. So this allows multinational companies to transfer workers across borders. That's really the easiest way of explaining this visa. And the corresponding green card allows for permanent sponsorship of those individuals who are in the multinational manager category. So this is one of, if you qualify, and it's a pretty small group of people who do qualify for the multinational manager green card, but it is one of the fastest and most efficient ways to get a green card, again, because policymakers have decided that that's a preferred category.
Great, thank you. So we're going to turn in a moment to Christine to talk about the cultural visas in the J1 category. But before we do, one more question for you, Becki. The last category that I want to just talk about is the O1, EB1A, and NIW, the National Interest Waiver. So we've heard a lot about the O1 visa as well in the news, and the corresponding green card that it has for individuals with extraordinary ability. So this category, along with the national interest waivers, are the only two categories of quote unquote self-sponsored green cards. Can you tell us a little bit about how those visas work?
Absolutely. So let's start with the O1. This is one of my favorite visas. And actually, this is the visa that you and I have worked on together quite a few times. So the O1 is a visa for aliens of extraordinary ability. And the regulations divide O1s into two groups. One are people in business and science and athletics, and then the second are people in the arts. So for that first group of people, O1 business people with extraordinary ability, they have to show that they're one of those at the handful of those at the top of the field worldwide. So a very, very high standard. The regulations talk about the Nobel Prize. I can tell you that not everybody we've gotten an O1 for in business is at the Nobel Prize level, but that gives you some sense that the standard is pretty high for the O1 in business. For arts, the legal standard is distinguished. And so that is a lower legal standard. You still have to show that you have risen above sort of the average person in your field, but not necessarily that you're among the handful of those at the top of the field worldwide. So it's a little easier to get this as an artist. And we do hear a lot of artists talk about the artist visa. This is typically what they're talking about when they talk about the artist visa. So this visa requires you to submit documentation that you're extraordinary. And there's a list of categories, and you have to satisfy 3 of those 10 categories. So the categories could be things like filling a critical role at a distinguished employer, having publications about you in major media, having published authored articles in major media, winning competitions, judging competitions. Those are just some examples. So when we put together one of these petitions, we document that the person is extraordinary through those types of accomplishments. And then the EB1A is the corresponding immigrant visa for someone in that category. So again, you don't have to have an O1 to get an EB1A. And you can get an EB1A without having had an O1, but the categories of evidence are very similar. The artists actually do have to be among the handful of those at the top of the field worldwide when they're applying for a green card. So it's easier to get a temporary visa as an artist, but not necessarily a permanent visa. And then the national interest waiver is another type of green card that allows for self-sponsorship. And so I kind of conceive of the national interest waiver as when someone is working in a field that is critically important to the US national interest. So the extraordinary ability visa requires the individual themselves to be extraordinary, but you could get it in any field. For example, I did one for a pantomime artist a long time ago. So I worked on a case for a pantomime artist. I met someone who did it for rave DJs. So the extraordinary ability can be for any field. The field doesn't necessarily need to be important to the US. The national interest waiver requires the field to be of national importance, but the foreign national doesn't have to be as highly skilled. Still very high level of skill required, but not as high. So these last two categories, the extraordinary ability and the national interest waiver, do, as you mentioned, allow for self-sponsorship. So an individual doesn't have to have a US employer to sponsor them. They could theoretically self-sponsor in those categories. So I think that wraps up the four categories that I wanted to talk about, and I'll turn it back to you.
Great, thank you. So reminder, we already have one question in the Q&A. Please do type in your questions in the Q&A chat box if you have any. We've just very briefly covered four different categories of visas, and we're about to cover one more. So if you have questions that you'd like to ask, please do feel free to type those in, and we'll get to as many as possible in the second half of this presentation. Christine, so thank you so much for joining us from your firm at Cultural Vistas. Would love for you to give us an overview of some of the cultural visa options that you specialize in, your firm specializes in, the J1 and any others. Can you tell us a little bit more about how those visas work?
Yeah, sure. So Cultural Vistas is designated by the U.S. Department of State to provide sponsorship for J1 visas as a part of the exchange visitor program. We work both with law firms and directly with companies to provide sponsorship for international visitors coming to the U.S. For employment opportunities. The exchange visitor program was actually established by the U.S. Department of State with the express purpose to facilitate the exchange of American business practices and culture between the U.S. and the world. There's 15 total different categories, and Cultural Vistas can host in 6 of those, and we focus more on the professional categories. And then within those categories, there are 3 that are more geared toward high-skilled individuals, those being the research scholar, short-term scholar, and specialist categories. I'll talk mostly about the research scholar and specialist today. The application for all of these are similar. Many companies are more familiar with a different category that we also provide sponsorship in. That's the J1 intern category, which is really popular for companies looking to bring students and recent graduates to the U.S. for internships. But the primary difference between that category and the scholar specialist category is that there's actually less paperwork for a scholar and a specialist. So research scholars are research professionals, right? It's in the name. They're coming to the U.S. to conduct research and work directly with American colleagues to exchange their knowledge and past research in American businesses. Scholars, we require they have a minimum of a bachelor's degree. And then beyond that, they need a combination of the requisite educational and work experience in order to do the jobs they're coming to the United States to do. Scholars can also stay in the U.S. for a pretty significant amount of time. Their programs can be as little as 3 weeks, but they can remain in the U.S. for up to 5 years. The big thing being they really need to be coming to the U.S. to do research. But it doesn't have to be at a big research institution. It can be at an R&D department within a larger company. It can be at a startup doing AI software development type research, and it doesn't need to be in STEM either. Although those are the majority of the programs that we see. And then there are J1 specialists. So specialists are subject matter experts, typically coming to the U.S. to observe, consult, demonstrate specialized skills. And then, of course, they do need the background necessary to show and prove that they are, in fact, a specialist in their area. We typically require a minimum of 10 years of experience. That's in combination of professional and educational experience. So someone with a postdoc, a doctoral degree, could qualify as a specialist maybe with just a couple of years of experience, whereas if someone doesn't have a degree or just a bachelor's degree, we require significantly more professional experience on their resume for them to qualify. Specialists also can't be filling like a permanent position within a company. So they really need to come to the US to be collaborating with an existing team alongside a manager, bringing those specialized skills to the US with the kind of grand final idea that when they're departing the US, a lot of that knowledge and expertise is remaining in the US to continue to be utilized by their company. What makes these options unique is just that they're a little bit more predictable in terms of the talent pipeline. There's not a cap. So they can apply for them year round. One thing to note is that there's something called the home country residency requirement, which is often referred to as 212E or the 212E home country residency requirement. That requirement states that someone whose area of expertise, their skills, if they are listed on the skills list, which is a list put out by the Department of State, then they must return to return to their home country or country of last permanent residence in order for 2 years before they can be eligible again for an immigrant visa in the United States and other non-immigrant visas as well, but primarily an immigrant visa or permanent residency in the US. So if your area of expertise is on this list, then you would be subject to the home country residency requirement. They hadn't updated this list in over a decade and then just did it back at the end of 2024. What was significant about that update is that previously China had been on that list and India, and those two countries were removed, and those are some of the most common countries that we see applications for J1 scholars from. And then another thing to be aware of is that it is a non-immigrant visa, but it doesn't have any of those corresponding, green cards or immigrant visas to go along with it. And that's because this is at its heart a cultural exchange visa. The idea being that, when they're here, they're learning about American culture, and then when they depart the United States, they're sharing that culture that they have learned abroad. So we are pretty strict about applicants whose intention, upon entering the United States is to apply for immigrant status. We do ask them to confirm that that's not their intention when they arrive here in the US.
Right. So thank you, Christine, for that overview. Okay, so we've just covered 5 broad categories of high-skilled immigration visas and green card options. We've talked about the H-1B and the PERM, which is for professional workers and labor certification. We've talked about the E and EB-5, which for treaty traders and investors, the L-1 for multinational managers and the corresponding green card, the EB-1C, the O-1, EB-1A, and NIW for people of extraordinary ability. And then finally, the J1 research and exchange. So very broad categories. Let's jump into a few questions. This one I think is for you, Becki, from Anonymous. For the manager visa, do you need to hold a degree in the role you are managing? For example, I'm a public administration major, but manage a construction inspection company.
So the L1A, the L1A is for multinational managers. The L1B is for specialized knowledge workers. The L1A does not have a degree requirement. If the individual in question has a relevant degree or a related degree, we usually include it, but it is not required to have a degree for a managerial role. You do have to show that you're qualified for the role. So if you don't have a degree, you would want to show relevant experience. An L1B for specialized knowledge worker also typically does not require a degree, and the exception is for what's called a blanket petition. So very large companies that file a very large number of L1 petitions that regularly transfer workers could qualify for a blanket, which allows them to transfer those workers more expeditiously And in that case, the L-1Bs do have to have a bachelor's degree. But no, for multinational managers, there is no degree requirement.
Great, thank you. The next question is from Marius, whose company is private equity owned and about to be acquired by a globally operating company. He says, I currently own an E2 visa plus awaiting a PERM result, which was submitted in January 2025. The question is about the ease of converting the E2 to the L1A, and what are the implications for my pending PERM or green card application if my company is acquired and I lose my E2 status?
Okay, I can address that. We should have had a disclaimer at the beginning. I can't remember if we did, but yes. Anything that we say on this webinar should not be construed as legal advice. So we will be happy to speak to sort of the general principles of law, but obviously if you have specific immigration questions, you should consult an immigration lawyer because each case is very fact specific. So having said that, I'm happy to talk to some of the general concepts. So the E-visa and the L-visa are often used by the same companies in very similar situations. So we have many companies that are, large global companies that will use both of those visas to transfer workers across borders. The main difference between them is that the E-visa requires nationality. And I think I didn't mention that, but that's an important one. So if the investor is Canadian, they can only transfer Canadians on the E-visa. If the company is Israeli, they can only transfer Israelis. So there's no requirement that if you, Mark happened to be Israeli and you set up an Israeli company in the US, you could find someone in Israel who'd never worked for your company before. There doesn't have to be a foreign affiliate of the company for the E-visa. As long as their nationality matches the nationality of the treaty company, they can be sponsored. For the L1, there's no nationality requirement, so you can sponsor someone of any nationality, but that person must have worked for the foreign parent, subsidiary, branch, or affiliate for 1 year. So I think, the fact pattern here sort of raises a question about whether, can you change from an E to an L? The first thing that we would look at is, did you work for a parent, subsidiary, branch, or affiliate of the US company for 1 full year before entering the US in E2 status? So you must have 1 year of experience in the past 3 years, or if you're in the US in another immigration status, it could be 1 year in the 3 years immediately preceding your entry to the United States. So if you met the qualifications for an L1, which, in many cases that's possible, but in some cases it might not apply, then yes, changing from an E to an L is something that's possible. And with regard to the PERM, that definitely can be complicated when there's a merger or an acquisition. A PERM is in process. There's a body of law about something called successor in interest. And so essentially the analysis is whether the acquiring company is legally a successor in interest to the company that initially filed the case. And if so, then typically that new company can take over the PERM, but that does require a very specific analysis. So that's how I would address that question. I do want to ask anyone who has a question to please put it in the Q&A section. There are at least 2 questions that are in the chat, but in order for our record keeping purposes, we would appreciate if you could move them to the Q&A and we'll be happy to address them from there.
Yes, thanks, Becki, and that's helpful for me as well because my Q&A box is open and my chat box is not. It's tough to monitor both at the same time. One question. So yes, please do cut and paste into the Q&A box. Question from Melech. What is the cost roughly of the L1 visa and how long does the processing tend to take?
So definitely I'm not in a position to quote legal fees on a webinar, but if someone is interested in the L1 visa, we'd be happy to do a consultation with you and then, provide a fee. But with regard to the timing, so assuming that this is a new L1 and the company has not qualified for L1 status before, the initial L1 is a pretty labor and time intensive process because you have to document the corporate relationship between the foreign entity and the US entity. Sometimes that's really easy. If it's a publicly traded company, there might be an annual report that explains the relationship. Sometimes it's really hard if it's a privately owned company, sometimes with a very complex corporate structure and often documents in a foreign language. So when you file something with the Immigration Service, anything that's not in English must be translated into English and accompanied by a certified translation. So when you get into companies where you have to translate the corporate documents, that process can be quite lengthy. And you do have to document every step in the ladder. So if it's a direct parent subsidiary relationship, that could be very straightforward. If there are sort of multiple companies along the way, you have to document the ownership of each company. So I think how long it takes would depend on how complex is the corporate structure. And then also whether, did this question relate to a multinational manager specifically?
It was just a general
Just an
question about
L1
the
visa. Yeah. So
although Mela followed up that he's a partner at a medical supply company in the UK and now has opened a separate company in the States that does similar work.
Got it. So, well, to go back to the question about timing and cost, so an L1A multinational manager visa would definitely be quicker than an L1B specialized knowledge visa. The L1B has been really, really highly scrutinized for many, many years now. And so the amount of documentation required for the L1B can sometimes be massive. For the L1A, it can typically be a lot easier to show that the person had a managerial role overseas. They'll have a managerial role in the US, and that's, more easily accepted. So I would say that, definitely quicker to do an L1. Typically it might take 2 or 3 months to put together one of these cases if you're actually you have to assemble all of the corporate documents, and the documents are in a foreign language, and the corporate relationship is not straightforward. So that's just a ballpark, but it really can vary widely.
I'm going to jump in with a question here from me, both for Becki and for Christine. Can you talk a little bit about how the current administration, we talk about these sort of 5 broad categories. Can you talk a little bit about how the current administration is perceiving some of these different visa categories, whether they've said anything favorable or unfavorable about any of these categories, and whether there are specific visa categories that they are either we perceive they're favoring or disfavoring, and how that could potentially impact the timing or how they're viewed or how we go about those petitions.
Christine, do you have any thoughts about the J1 in the current administration that you would like to share?
Sorry, I couldn't find my unmute button. So we have not had, been no orders, no policy changes that have affected the J1 directly. We've just been more broadly affected by other measures that have been in place, like extended wait times at consulates and a little bit of less transparency there. During the previous Trump administration, he pretty quickly made some changes that directly affected the J1 visa and caused us a lot of trouble, a lot of problems. But this time around, we have not really had any direct issues, and we haven't heard anything that we should be expecting any big changes coming down the bend.
Thank you. I would say, with regard to the categories that I discussed, the only one that really has been mentioned in the news is the EB-5, and that was in conjunction with the gold card that was raised last week. So the president did say that he wanted to do away with the current EB-5 category. That was passed by Congress, so it would require legislation to legally end that program. And it is designated for several more years. So, the other categories, We haven't heard much about yet. Many of them were impacted, especially the H-1B during the first Trump administration. And in fact, the current H-1B lottery system that we have was created during the first Trump administration. So we are, expecting that changes may be coming down the pike, but I think certain players in the administration are very in favor of these high-skilled visas and others are not. So it remains to be seen really what position the administration will take on these visas.
Okay, great. Yeah, very, very helpful. I'm going to go to the chat box very quickly, although encouraging people to continue typing their questions in the Q&A box. One question from Tarek. Due to the recent changes affecting federal workers in the DC area, should one be concerned about the PERM certification process when applying for the EB-2?
I assume this question relates to processing times and whether the termination of federal workers will impact processing times. And if so, the answer is yes. We do expect that that government layoffs will affect processing times at the Immigration Service, which processes step 2 and usually step 3 of the PERM-based green card process. There have only been about 50 layoffs so far. Again, it remains to be seen. It does seem from what we've read in the news that they intend to continue laying off government workers. So it's hard to know where those cuts will occur. But, we do expect that processing times for most immigration processes will slow down, including these high-skilled categories.
Great, thank you. This is an interesting one from Anonymous. Any thoughts on Trump and Elon Musk's past comment, the president and Elon Musk's past comments about granting PhD students an automatic green card upon graduation? Do you think such a policy is feasible or likely to be implemented?
I love that idea, but if I were a betting person, I would not bet on that.
Right. Okay. Another question from the chat from Alessandra. Any thoughts on potential about a change from a temporary protected status, TPS, to H-1B or L-1 visa? Any insight that you can share on that?
So I have to confess that it's been very hard to keep track of all of the changes relating to humanitarian statuses and changes to a high-skilled worker visa. So I can say that in the past, we have had clients who changed status from TPS to other types of visas, but I would not want to cite the current law on whether that's possible. So I would say that's something, we could consult on if that was something that you wanted, to have a closer look at, but I'm not positive what's the current policy on that.
Okay, thank you very much. Welcome any additional questions on that are coming into the Q&A box. One question that I wanted to pose, there's been discussion of potential additional travel bans, sort of follow-ons from the first Trump administration. Can you discuss the impact, if any, on potential travel bans, even though we don't have a lot of the details, how that would impact any of the any folks with potential visa categories that we've discussed today?
We can definitely talk about potential travel bans. There was an article, I think it was in Reuters today, but don't quote me on that, about a potential travel ban for Afghans and Pakistanis. So those were the only 2 nationalities that were specifically mentioned, but we certainly would not be surprised to see travel bans on other nations. Project 2025 did mention several specific countries that might be included in a travel ban. So the way that a travel ban worked was that if you were from one of those countries, you could not get a visa, with certain exceptions. So there was something called a national interest exception, which when there were travel bans, that was something that clients sometimes asked us to do, to see whether they could be issued a visa if, despite the travel ban, what they wanted to do in the US was in the national interest. Those were the NIEs, as they were called, were issued very sparingly. I don't know whether that process will be available again. I would imagine it would be, because even if there is a blanket ban, there might be some individuals traveling from those countries that the administration would want to let in. But I would expect any waivers to be very limited and granted, very infrequently. Christine, did the travel bans have an impact on your J1 programs when those were in place? There were COVID travel bans and a Muslim travel ban.
Yes, they were quite a problem during the first administration. We were that was one of our biggest worries with him coming into office, was whether or not we would see similar bans coming into effect this time around.
Yeah. And I think it's really hard to get a national interest exception for a J1 because of its temporary nature. Someone who maybe is an O1 and is doing something really important in the national interest has a much better chance of getting an exception to a travel ban than someone who might be coming on a more temporary basis as a J1. So
that wasn't an option that we typically would give to applicants at the time.
Thanks. Okay, so Anonymous asked, do we do these services for private people? Yes, we are an immigration law firm. Happy to be in touch with anybody following this webinar who may have specific questions or need specific services. And so please do be in touch with us. We'll follow up with our information. Amanda asked, has there been any communication on advanced parole? I know in the first term, there was discussion about canceling it. Becki, any insights on that?
We haven't seen anything specifically about advanced parole, but it's important to know there are a lot of kinds of parole. So we have seen a lot about humanitarian parole. United for Ukraine is a kind of humanitarian parole, and it was just published today that it's likely that program will be ended probably in the month of April. There was Afghan parole and a variety of other humanitarian parole options. So those have definitely been impacted. Again, nothing specific about advanced parole yet, but could be coming down the pike.
Great. And then finally, I think this is the last question that I see from Alessandra. Not sure if we want to touch on this or have a follow-up on this particular question, but if we can on this webinar, would you be able to give us a brief overview of the G325R form? Becki, do you have any insights on that?
That's an excellent question. So the G325R form is the registry form. And in short, the administration recently announced that it was going to enforce a requirement that all foreign nationals have to register with the federal government. So this requirement has been on the books for as long as I've been practicing immigration law, but has not really been enforced. And it doesn't apply to most people who are in the US legally, because anyone who has a green card, so if you have a physical green card, or if you've been issued an immigrant visa, that immigrant visa typically says at the bottom, when endorsed, serves as an I-551. So an endorsed immigrant visa also counts as a green card, or which is registration. So if you have a green card, you're registered, you're good. If you have an employment authorization document, which is a driver's license size employment card, you're registered, you're good. And then if you have an I-94, which is the document that you get upon being inspected and admitted to the US, you're registered and you're good. So if you present yourself at a port of entry, let's say you're one of Christine's J1 research scholars, you get your visa, you come to the port of entry, you're going to be inspected, admitted, and an I-94 will be issued to you. It used to be back in the day that they would issue you physically a small white card or green card if you were coming from, not a green card like a green card, but a paper card that was green in color. If you were coming from a visa waiver country. So you used to get a physical I-94. These days you don't get a physical I-94, but it's very, very important that if you come to the US that you retrieve your I-94. I usually, if I want to help a client with this, I will just Google retrieve I-94 online, and that will take us to the US Customs website where you can retrieve your I-94. So you want to be sure that you were issued an I-94 on entry, because most of the time they get it right, but we definitely see all the time that somebody was admitted in the wrong category or for the wrong period of time. And so if your I-94 is incorrect, you want to get it corrected as soon as possible because of this registry requirement. So if you were inspected and admitted and you have an I-94, or if you have a green card, or if you have an employment authorization document, and there are a few others, but those are the main ones, then you are registered. Who is not registered are people who entered without inspection and do not have a lawful status right now. And so those individuals are required, they are required under current law, but it's expected that a new registration system will be created for those individuals. So as I said, this law has been on the books forever, but there isn't really a good way to enforce it right now. And so we were expecting the registry rule to come down this week. I haven't seen it yet, but the week is not over yet. So stay tuned. The Immigration Service has an online system called My USCIS. And so either earlier this week or last week, they released an announcement asking anyone who is subject to registry, meaning anyone who doesn't have one of those documents that I mentioned, to create a My USCIS account, and that further instructions would be forthcoming. And so the G325R form that the commenter mentioned is the form that will be required for the registry. So this is all new. I haven't actually seen the form yet. I'm not sure whether the form has actually been released, but I do know that that's, what we're talking about, and we do expect it to be released imminently. I think it's important to understand that there are definitely potential consequences to not registering. So for those who are subject, it is a legal requirement to register, and it's a misdemeanor not to register. And certainly as lawyers, we could never advise somebody not to follow a legal requirement, but we do think it's important for individuals to understand the potential consequences of registering. So if there are individuals who are faced with registration who want advice about what that could potentially mean for them, that is something that we would be able to consult about.
Wonderful. So as Becki just mentioned, if you are interested in scheduling a consultation with our firm, we put the information in the chat and in the Q&A. We are here to help. We'd love to be in touch with any of you who have follow-up questions on this. Thank you so much again to Christine for making the time, for joining us today. Thanks to Becki for your very helpful and educational overview. And thanks to all of you for joining in. We look forward to seeing you all soon and to being in touch with any further immigration questions that you may have. So thank you all very much again for joining us, and have a great day.